Good afternoon. I'm just waiting a moment for people to be able to join us. Good afternoon. I'm Erwin Chemerinsky. I thank all of you for taking time from your busy schedules to come to this town hall. I think one of the developments from the last year that I want to continue into the future is these alumni town halls over Zoom, because it allows us to bring together people from all over the country, allows me to tell you what's going on in the law school, and also to talk about a topic of mutual interest. I look forward as travel resumes to go around the country and meet with alumni in person, but I hope we'll continue to also do these Zoom alumni town halls. As always, I'd like to do two things this afternoon. First, I want to give you a quick update about what's going on in the law school. And then second, I was asked to talk about the Supreme Court as it's finishing October term 2020. I'll then, as always, save a good deal of time for questions. You can ask me anything you want about the law school. I'm glad always to take questions and talk about the United States Supreme Court. In terms of the state of the law school, overall, we're in good shape. As you know, all of our classes were online throughout the academic year. It was a hard academic year. Many of our students, some of our faculty really were struggling. For some of our students, this was a difficult form of education. Some of our students had to struggle with the illness, family members, and loved ones. For our faculty, especially with young children, it was a hard year. But there's also a sense that we made it. We did it. I always read the student evaluations at the end of each semester. I learn a great deal from them. And our median student evaluations this semester were higher than they'd been any semester since I've been at Berkeley Law. I was worried that the frustrations being all online might be taken out with regard to the student evaluations, but just the opposite. And I actually think that's a wonderful reflection of how hard our faculty worked to adapt to this new medium of instruction and how understanding and patient our students were. We're going to be all in person the fall semester. Classes begin on Monday, August 16th, and we've announced that the classes are going to be entirely in person. There'll be faculty and students in the classroom. There'll be no hybrid or remote option available. I have to tell you personally, I am so looking forward to Monday morning, August 16th at 8:40 a.m. when I can walk into my federal courts class and be with a room of students. It's something that I've taken for granted during all these years as a law professor, but it's been a long time, if ever, before I take it for granted again. Well, let me touch on several things by way of update with regard to the law school that might be in your mind. The first is admissions for the class that will begin in August. The news here is stunning. I guess the only way I can possibly put it is it's an embarrassment of riches for us. Our applications were dramatically higher this year. A year ago, we received 5,500 applications, but we wanted to be a class of 320. This year, we received over 8,000 applications for a class of 320. Nationally, applications were up, but ours were far in excess of what we've seen around the country. We wanted to reduce our class size. We wanted to be at 320. So our admissions office took 5% fewer students. But we, like our peer law schools, have had an extraordinary yield. This year, 37% of all the students we accepted have decided to enroll in Berkeley Law. That is by far the highest yield that Berkeley Law has ever had in its history. The result is that at this moment, while we want a class of 320 students, We have 420 who said they're going to come. Now, there's much about this that's great. Their median numbers are terrific. The median LSAT is 169, which would be the highest in the history of Berkeley law. The median GPA is 3.84, which is high as it's ever been. The diversity of the class is great. Their accomplishments are wonderful, but it is a lot more students than we had planned to have in our classes and in the building. We sent a letter to them yesterday, encouraging them if they'd like to wait a year to defer, but of course saying we welcome them if they choose to come this fall. And we're looking at a whole range of other things that we can do to try to lessen this impact. As I say, there's ways in which it's flattering and great that such a large percentage of the students we accepted want to come to Berkeley, but it's also going to be really a challenge in terms of how do we handle it in terms of classrooms and other space. For our LLM students, it's more uncertain because a lot for them is going to depend on visa availability, but we look again to have a robust LLM class. Our target is 220 LLM students to begin in the fall. And I think we'll be able to meet that target, but again, so much is uncertain for them. A second thing you might be interested in is our employment numbers. Employment, you might know, is measured 10 months after graduation. So for the class of 2019, we had 98% employment in full-time jobs 10 months after graduation. For the class of 2020, it was just under 96%. I was very worried what the jobs would be like. I remember the recession of 2009 and worried that we'd be replicating that, but it didn't happen. Now, in fact, the percentage I gave you of just under 96% is a bit artificially low. It's measured as who's employed on March 1st because the bar exam was later. Some employment started later. So there were 3 students who have full-time jobs, but weren't counted in that 96%. So if you put them in, it's very close to what it was a year ago. That's for a law school remarkably like full employment. There's always some students who graduate who want to go get an advanced degree, an MBA or a PhD, and they count as unemployed. There's always a student or two for family reasons isn't going right into the workforce, and so they count as unemployed. But the job market has really held. And for that, of course, I have to thank so many who are on this call, our alumni, who continue to consider, continue to hire Berkeley Law graduates. Third topic is faculty hiring. We have 2 new faculty who are joining us on July 1st. And they are really great. Jennifer Chacon is a professor at UCLA, specialized in immigration law and also teaches constitutional law. Jonathan Glader is also a professor at UCLA, specialized in education law and teaches criminal law. They are wonderful teachers and great scholars and just outstanding colleagues, and thrilled to welcome them to the law school. One of the hard parts, though, is seeing some of our great colleagues leave. I find that one of the most difficult parts of my job is how many of our faculty are constantly being recruited by other law schools. On the one hand, I'm glad we have a faculty that's in such esteem and demand around the country. On the other hand, I wouldn't mind if some of these other law schools would show a little bit less love and attention to our faculty. We do have 2 faculty who are leaving us. Bertrell Ross and Joy Milligan are going to the University of Virginia Law School, and we're going to tremendously miss them. We continue to do hiring. I just heard this past weekend that we've been approved to hire 6 additional faculty in the coming year to start July 1st, 2022. And so much of the quality of any educational institution is based on the quality of its faculty. And we have to continue to hire the very best faculty in the country, both at the entry level and at the more experienced levels. Finally, there's our budget. And if you ask me what keeps me up at night worrying about the law school, it's whether we'll have the funds to be able to compete with the other top law schools and remain at the very top in so many disciplines. You might have seen in the March US News Berkeley law was ranked, some of these are ties, 1 in intellectual property, 1 in environmental law, 2 in criminal law and criminal procedure, 3 in business law, 6 in constitutional law, 6 in international law, 9 in clinical education. This was a difficult financial year for the law school. As I'm sure you know, we've become very dependent on LLM revenue, and the LLM program for this past academic year was less than half the size it was before, and that cost us $9 million in revenue. The campus had a difficult financial year. We don't get that much money from campus, but they cut what they gave us by $2.5 million. And we don't get that much from the University of California Office of the President, 1.8 million total a year ago. This past year, they cut it to 1.3 million. Next year, they're cutting it to 1 million. If you do this simple arithmetic, that's a loss of $12 million in revenue compared to the year before. Our overall budget this past year was about $115 million. So losing 12 million out of $150 million budget is tough. And especially when you think that most of our budget is fixed costs, about 65% goes to faculty and staff salary and benefits, 20% goes to scholarships, and so on. But I was committed we would get through this year without any cuts in our academic program, without any layoffs of staff, and we succeeded. We didn't reduce the educational program in any way. We didn't lay off any staff. We did run a deficit this year, but we had the reserves to cover it. But it's been a tough fiscal year for us. And if you haven't given a gift this fiscal year, would certainly appreciate one. Even if it's a small gift, all of the support from our alumni makes a huge difference. And so this is my appeal. If you haven't given, or if you haven't, you can give again. It would be enormously appreciated in these last couple of weeks of the fiscal year. So that's my report on the state of the law school. Let me shift and talk about the Supreme Court, and then I'm glad to answer any questions you have about either. Obviously, the biggest difference in the Supreme Court this term compared to a year ago was the death of Justice Ruth Bader Ginsburg on September 18th, 2020, and the confirmation of her replacement, Justice Amy Coney Barrett, on October 26th, 2020. I neither want to overestimate the significance of this change nor understate it. I think a statistic from last term is particularly revealing. Last year, the Supreme Court decided 53 cases with signed opinions after briefing and oral argument. 14 of them were 5-4 decisions. In 10 of the 14, the majority was Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. Well, replacing Ginsburg with Barrett wouldn't likely have affected anything but the outcome in those cases. They still would have had the same majority, and I think it would have been a 6-3 rather than a 5-4 decision. Based on everything we know about Barrett, she's far more likely to side with the conservatives than the liberals. She was a very conservative federal court of appeals judge, a very conservative law professor. So in the 10 cases last year that were 5-4, I think they would have been 6-3. And already this year, we've seen a whole number of 6-3 decisions, and I predict we'll see a lot of that. On the other hand, of the 14 5-4 decisions, there were 2 where the majority was Roberts, Ginsburg, Breyer, Sonora, and Kagan. I think that those 2 cases likely would have come out different if Barrett were on the court. One struck down a Louisiana restriction on abortion. The other said that President Trump couldn't rescind the Deferred Action for Childhood Arrival program. Based on all we know about Barrett, those likely have been 5-4 in the other direction. The other 2 5-4 decisions had unique majorities. I think it's going to be much harder for the liberal justices to create a majority. Simple arithmetic. It's harder to get 2 votes than it is to get 1. But it's also important to remember that on the current court, there are 5 staunch conservatives: Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Roberts is a moderate conservative. And then you have 3 justices left of center: Breyer and Kagan, and then the most liberal justice now, Sotomayor. Maybe the most important thing I have to say is to remember this is not a short-term phenomenon. Consider the age of the conservative justices. Let me focus on it as of the day Amy Coney Barrett was sworn in, October 26th. She was 48 years old when she was sworn into the Supreme Court. If she remains on the court until she's 87, the age which Justice Ginsburg died, Barrett will be a justice into the year 2059. When Barrett was sworn in, Neil Gorsuch was 53, Brett Kavanaugh was 55, John Roberts was 65, Sam Alito is 70, Clarence Thomas is just 72. I've long thought one of the best predictors of a long lifespan is being confirmed for a seat on the Supreme Court. Remember, Justice Stevens didn't retire until he was 90. Justice Ginsburg was on the court till she died at age 87. So it's easy to imagine this group of justices being together for another decade or two. Well, what about this term of the Supreme Court? October term 2020. The Supreme Court has decided about 2/3 of the cases that have briefed and argued. The other third will come down in the next 2 weeks. I predict the court will finish as usual before July 1st. Last year it went to July 12th, but remember a year ago there were oral arguments in May, which we didn't have this year. Let me talk about 2 cases that have already been decided, and then alert you what I think are the most important cases that are still on the docket to be decided. For those of you who do intellectual property work, the most important case of the term already has come down, Google versus Oracle. And even if you don't do copyright, I'm sure you followed it in the news. It involves Google, which was making its Android phone. It wanted to use some lines of code from the Java software program. This was about its interoperability, the ability of the phone to be able to connect to other things. Google tried to negotiate with the owner of Java, then Sun Microsystems, to get a license. The negotiations fell apart. Google went ahead and copied the lines of the Java software program without getting permission, without having a license. Oracle then purchased Sun Microsystems and sues Google for copyright infringement. Well, there are 2 issues that come to the Supreme Court. First, is such software code copyrightable? And if so, is the action by Google in this instance fair use? The Supreme Court in a 6-2 decision ruled in favor of Google and against Oracle. Justice Breyer wrote the opinion for the court. The dissent was Justice Thomas, joined by Justice Alito. Justice Breyer said the court wasn't going to address the first question, is this code copyrightable? But instead focused entirely on the second issue, is it fair use? Now, if you practice in the area of copyright law, you know that courts often look at 4 factors in assessing fair use. One thing that's looked at is the purpose and the extent of the defendant's use. The more the defendant's use can be said to be, quote, transformative, the more likely it is that it's going to be action that the defendant can do. Another second question is, what's the nature of the copyrighted work? The more the plaintiff's work is creative, the more protective courts want to be. Third, what's the amount, the substantiality of the defendant's use? How great is the copyright infringement? And fourth, what was the effect of the defendant's actions on the market for the plaintiff's work? Well, looking at those 4 factors, Justice Breyer said that what Google did in copying the Java software program without a license constituted fair use. It's interesting that Justice Breyer's opinion gave very little weight to whether there was any harm to the market from Java as a result of Google's activities. Justice Breyer also emphasized that putting the Java code to new use was transformative, and that mitigated in favor of a conclusion of fair use. But most of all, I think that Justice Breyer's opinion here weighed the harm to the plaintiff against the public interest in allowing what the defendant did to go forward. And I think here, Justice Breyer's opinion gives enormous weight to the perceived public benefit of what Google had done in using the Java program to develop the Android phones. Now, Justice Thomas, in his dissent, believed that what Google did was just wrong. It could have gotten a license. It should have gotten a license. And to copy the software without it should be regarded as copyright infringement. This is an issue that had been around in the lower courts for a while. When the Supreme Court last tried to deal with it, there was a 4-4 split. This, I think, is the court providing much guidance, needed guidance in the area of copyright law. The second case that's already been decided by the Supreme Court that I want to talk about, certainly of interest to those of you who are civil litigators. It's Ford Motor Company versus Montana 8th Judicial District, and it concerns personal jurisdiction. We all learned about personal jurisdiction in civil procedure. I'm trying to think about who some of you on this call had for civil procedure. Maybe some of you had Jan Vetter, Steve Bundy, Willie Fletcher. Well, when you learned about civil procedure, you undoubtedly read the International Shoe case. There, the Supreme Court said that absent consent, the defendant can be sued in another state only if the defendant has minimum contacts with that state. Subsequent to International Shoe, the Supreme Court found two ways of there being minimum contacts: general jurisdiction and specific jurisdiction. General jurisdiction, the Supreme Court has said, now means that the defendant is home in the state. There's only general jurisdiction under current law if the defendant is home in that state. And the Supreme Court has said a corporation, for example, is home where it's incorporated and which its principal place of business. The other way of finding jurisdiction is specific jurisdiction, but that requires that the defendant's contacts with the state give rise to the cause of action there. To make this less abstract, there was a Supreme Court case 4 years ago, Bristol Myers Squibb versus Superior Court. It involved a lawsuit against the major drug company, Bristol Myers Squibb, for the side effects of a heart drug that it marketed and sold. A lawsuit was filed by a number of California residents, but then some out-of-staters who had been injured by the same drug joined their lawsuit. Bristol Myers Squibb moved to exclude and dismiss for lack of jurisdiction the latter group. The California Supreme Court ruled in favor of the plaintiffs. It acknowledged there wasn't general jurisdiction because Bristol Myers Squibb isn't home in California. It's incorporated in Delaware. It's its principal place of business in New York. But the California Supreme Court said there was specific jurisdiction because there was no unfairness to it, to having it tried in California. It was already being sued in California. It said that personal jurisdiction is ultimately about fairness to the defendant. The Supreme Court, in an 8-1 decision, reversed. Justice Alito wrote for the court, only Justice Sotomayor dissented. Justice Alito said there's no general jurisdiction. Bristol Myers Squibb isn't incorporated, doesn't have its principal place of business in California. And then he said there's not specific jurisdiction. For the plaintiffs who bought their drugs out of state and were injured out of state, they shouldn't be able to sue in California. Well, this brings me to the case that was decided by the Supreme Court earlier this year, Ford Motor Company versus Montana 8th Judicial District. It was two cases that were consolidated for decision. One, the Ford Motor Company's 8th Montana Judicial District, involves a man in Montana who went out of state, purchased a used car, came back to Montana, and was seriously injured. In fact, he died as a result of a car accident. His estate sued Ford Motor Company for design defect in the car. The companion case, Ford Motor Company versus Bandemere, involved a man in Minnesota who had gone out of state, purchased a used Ford car, came back to Minnesota and was in a serious accident where he suffered severe brain damage. Suits were brought against Ford in each state. In both instances, Ford moved to dismiss for lack of personal jurisdiction. Ford said, we didn't sell them their cars in Montana and Minnesota, respectively. Therefore, we're not liable. The state Supreme Courts ruled against Ford, and the United States Supreme Court agreed and ruled against Ford. Justice Kagan wrote the opinion for the court. The result was unanimous, though not all of the justices joined her opinion. Justice Kagan related the familiar language of the minimum context test, the ability to have general or specific jurisdiction. And she said, as to specific jurisdiction, there are two factors to consider: purposeful availment and relatedness. She says there was purposeful availment here because Ford Motor Company is regularly marketing, selling, servicing cars within states of Montana and Minnesota, respectively. She said, as to relatedness, she said, this case is related very much to the behavior of Ford. It, for example, has a network of service opportunities in both Minnesota and Montana. So make it attractive for people to buy their Ford cars, knowing they can come home and have them serviced. Based on all of this, the Supreme Court said there was specific jurisdiction, Ford Motor Company could be sued. This certainly provides important guidance for you as lawyers. The court for the first time has said, when it comes to specific jurisdiction, it's about purposeful availment and relatedness. Now, admittedly, the court doesn't define either of those two terms, and there's going to be a good deal of litigation, but at least the court's given us the criteria to apply. On the other hand, I find puzzling here how this case is any different from Bristol-Myers Squibb versus Superior Court. Remember, that case involved a major drug company marketing and selling drugs in California, where their out-of-state plaintiffs could sue. The Ford cases involve individuals who purchased their car out of state, were injured in the state. Could they sue Ford in those states? Now, Justice Kagan, in her majority opinion, distinguishes Bristol-Myers Squibb and says that in these two cases, the plaintiffs were suing in their own home state. Bristol-Myers Squibb involved what looked to be forum shopping. But I confess, I find that ambiguous and even troubling. The court has always focused personal jurisdiction solely on the defendant. And did the defendant have minimum contacts with the state? Now what Justice Kagan's doing is focusing on the plaintiff. And did the plaintiff have adequate contacts with the forum state? Or was the plaintiff forum shopping? But why should that matter for personal jurisdiction? And if it does, how has it changed the law? Well, those are the two cases that have already come down this year that I want to talk about. I want to identify for you what I think are the four most important cases still to be decided. The court will release decisions tomorrow morning at 10 o'clock Eastern time. And the pattern seems to be right now Mondays and Thursdays, though often the last week they have more decision days. The first case that I would talk about concerns the Affordable Care Act. And the case is Texas versus California. You might remember that in 2012, in National Federation in Business versus Sebelius, the Supreme Court upheld the constitutionality of the Patient Protection Affordable Care Act. The central issue in that case was whether the individual mandate was constitutional. the individual mandate is a requirement that people purchase insurance or pay a tax penalty. And the Supreme Court 5-4 found that the individual mandate was a constitutional exercise of Congress's broad power to tax for the general welfare. In December 2017, as part of President Trump's tax reform bill, Congress eliminated the penalty for those who do not purchase insurance. There's still a requirement that a person has to purchase insurance, but no longer is there a tax consequence to failing to do so. Texas brought a lawsuit in federal district court saying that this makes the Affordable Care Act unconstitutional. Texas said the individual mandate was upheld because it was a tax. There's financial consequences to not buying insurance, but now there are no financial consequences. It can't any longer be thought of as a tax. And the state of Texas said the individual mandate is the linchpin to the entire Affordable Care Act. Without it, the whole law should be struck down. The Trump administration intervened on the side of Texas and also argued that the Affordable Care Act is unconstitutional. California and other blue states intervened to defend the Affordable Care Act. The federal district court agreed with Texas that this makes the Affordable Care Act unconstitutional. The United States Court of Appeals for the Fifth Circuit in a 2-1 decision affirmed in part and remanded in part. The Fifth Circuit agreed that no longer could the individual mandate be regarded as a tax because there's no penalty, but it said that the question of whether this can be severed from the rest of the law had to be resolved by the lower court first. It remanded the case back to the district court. But before the district court could do anything, the Supreme Court granted certiorari. 3 issues before the Supreme Court. First, does Texas, do the other states, have standing to be able to sue? Are they injured in some way? Second, if they're standing, then is the individual mandate unconstitutional? Does it still fit within the scope of Congress' powers, even though there's no longer a tax penalty? And if it is unconstitutional, third, is it severable from the rest of the statute? This is the question of, would Congress likely have adopted this law without the unconstitutional portion? Now, I would think that would be clear. You might remember in December of 2017, there was a proposal to eliminate the entire Affordable Care Act. It failed in Congress. You might remember Senator John McCain, near death, coming to cast the decisive vote to uphold the Affordable Care Act. So if severability is the issue, this provision does seem severable from the rest. On the one hand, we're in the midst still of the worst pandemic, the worst public health situation in over a century. 21 million people get their health insurance through the Affordable Care Act. Would the Supreme Court really strike it down now? On the other hand, everything about the Affordable Care Act has been partisan from the beginning. Every Republican in Congress voted against it. With a very conservative court, might they see this as the time, the occasion for striking down the ACA? The second area that I want to talk about, major decision to look for, is Fulton versus City of Philadelphia. Philadelphia contracts with private social service agencies to place children in foster care. Philadelphia insists that these private agencies agree not to discriminate based on race, sex, religion, sexual orientation. Catholic Social Service said it couldn't attest to that because of its religion, it wouldn't place a child with a same-sex couple. The Catholic Social Services brought a challenge in federal district court saying that the requirements applied to them violated the First Amendment. They said it violated the First Amendment free exercise of religion. They said it violated freedom of speech. They said that by forcing them to attest that they wouldn't discriminate, it was impermissible compelled expression. The federal district court in Pennsylvania ruled against Catholic Social Services and upheld the Philadelphia requirement. The United States Court of Appeals to the Third Circuit affirmed, and the Supreme Court granted review. Case was argued on Wednesday, November 4th. It didn't get as much media attention because of all else that was in the news on that day, but it is an enormously important case. It represents an issue that's much litigated in the lower courts and not decided by the Supreme Court. When people are allowed to discriminate against others on account of their religious beliefs? This was the issue 3 years ago in the Supreme Court in the Masterpiece Cake Shop versus Colorado Civil Rights Commission. Could a baker claim a First Amendment right to not design or bake a cake for a gay couple by saying it violated the baker's religious beliefs? There's certainly cases on their way up to the Supreme Court that involve florists and videographers and stationery stores that won't serve same-sex couples. And there's laws in states like California that prohibit such discrimination. To what extent does free exercise of religion provide a basis for people to discriminate against others? Or another example, almost exactly a year ago, June of 2020, the Supreme Court said that Title VII of the 1964 Civil Rights Act, that its employment discrimination, among other grounds based on sex, also forbids employment discrimination based on sexual orientation or gender identity. But the court explicitly left open the question of what if the employer who has a religious objection to have a gay, lesbian, or transgender employee? Then does free exercise of religion provide a basis for protection? The third area that I want to talk about that's before the court concerns freedom of speech, and it's the Mahoney Area School District versus BL case. BL was a high school sophomore at a public school in Pennsylvania. She tried out for the varsity cheerleading team. She was disappointed to learn she was just on the junior varsity. But then when she learned that a freshman made the varsity ahead of her, she was livid. She went on Snapchat. She posted a message with her extending and raising her two middle fingers. She repeatedly used a profanity that starts with the letter F. She then did another recording over Snapchat, but one that was much briefer and didn't have the profanities. Even though she had a limited following on Snapchat, her message got widely circulated within the school community, and the high school cheerleading coach removed her from the team. He said she could try out again the next year. He said there's no other sanctions imposed by the school, but she couldn't be a cheerleader during that year. The federal district court granted an injunction saying that the girl had to be reinstated. She couldn't be excluded on this basis. And ultimately, the district court ruled in favor of the girl against the school that had suspended her from the cheerleading team. And the United States Court of Appeals to the Third Circuit affirmed. The Third Circuit said, under the leading Supreme Court case, Tinker versus Des Moines Board of Education, a student can be disciplined only if speech is actually disruptive of school activities. This speech was not actually disruptive of school activities. But the Third Circuit went even further. And the Third Circuit said that students can never be punished for speech off school, not in school hours. In this instance, her tweet was sent over the weekend and not from school grounds at all. On the one hand, the Third Circuit position provides a bright line rule. Students never can be punished for their speech over social media in non-school hours. On the other hand, schools have a legal as well as an ethical duty to deal with bullying, to deal with harassment that occurs, sexual or racial harassment, over the internet. I don't think it's a sufficient answer for the say that schools can never punish student speech ever that's outside of school hours, no matter how egregious the bullying or the harassment. So on the one hand, I find this an easy case. The girl's speech wasn't disruptive of any school activities. There's no showing that it caused any harms. On the other hand, I think that the underlying issue is an enormously difficult one of under what circumstances can schools punish student speech that's out of school on weekends, such as I say, if it's bullying or harassment based on race or sex. But we'll see. The Supreme Court heard oral argument in April. It'll come down in the next couple of weeks. The final case to be out on the lookout for concerns voting rights, and it's Arizona Republican Party versus Democratic National Committee. I regard the Voting Rights Act of 1965 as one of the most important federal statutes adopted in my lifetime. Section 2 of the Voting Rights Act prohibits state and local governments from election practices that have a discriminatory effect against minority voters. Section 5 said, as for jurisdictions with a history of race discrimination voting, they get a significant change in their election system only if they first got pre-approval, pre-clearance from the Attorney General or from a 3-judge federal district court. In 2013, in Shelby County versus Holder, the Supreme Court 5-4 struck down the pre-clearance requirement. We see the practical consequences now. Georgia is a state with a long history of race discrimination voting. If pre-clearance still existed, it would need to get that approval before its restrictive voting law could go into effect. But the Supreme Court struck down pre-clearance and nothing like it exists. Now, this is an important limitation in the protection of voting rights in the scope of the Voting Rights Act. But there's still Section 2, which allows people to sue to challenge election systems that have a discriminatory effect, intent with regard to minority voters. And that's what Arizona Republican Party versus Democratic National Committee is about. It concerns 2 restrictions on voting imposed in Arizona. One said that a vote would be counted only if the ballot was cast in that particular person's precinct. The other said that only a person or a relative could turn in an absentee ballot, no so-called ballot harvesting. The Ninth Circuit, in an en banc opinion by Judge William Fletcher, found that the Arizona law violated Section 2 of the Voting Rights Act and also had a discriminatory intent so as to violate the Constitution. I think that what the Supreme Court does in this case, and oral arguments were in April, going to be hugely important. We're seeing around the country a whole wave of restrictive voting laws adopted in states like Georgia, in Florida, Arkansas. They are going to be challenged under Section 2 of the Voting Rights Act. Whether the laws will be upheld or whether they're likely to be struck down could well depend on what the Supreme Court does in this voting case in the next couple of weeks. Well, if that's not enough, the court already has on its docket for next term blockbuster cases, even ones that would likely overshadow these. So the court has before it Dobbs versus Jackson Women's Health that involves a Mississippi law that prohibits abortions after the 15th week of pregnancy. The core of Roe versus Wade is that states cannot prohibit abortions before viability, time at which the fetus can survive outside the womb. Viability is generally thought to be the 23rd or 24th week of pregnancy. In Planned Parenthood versus Casey in 1992, the Supreme Court said that the essential holding of Roe versus Wade was that states could not prohibit abortion before viability. And yet that's exactly what the Mississippi law does. I fear now 5 justices at least to change the law with regard to abortion, and I think likely overrule Roe versus Wade. Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, in this case, just next fall, could provide the vehicle. There's also an important case with regard to gun rights. It's interesting, from 1791 to 2008, no regulation of guns, local, state, or federal, was struck down by the Supreme Court. But in 2008, in District of Columbia versus Heller, the court declared unconstitutional a DC ordinance to rid ownership or possession of handguns. Justice Scalia's majority opinion was narrow. It focused on a right to have guns in the home for the sake of security. New York restricts weapons outside the home. It says people can't have a carry a concealed weapon unless they have a concealed weapons permit, and they need to have special reason, good cause for having this. The lower courts upheld this, but the Supreme Court granted review. I think there is now a majority of the justices that want to substantially expand gun rights, and we're likely to see that next year. Well, with all of that in mind, let me pause now and glad to take questions. You can ask me about anything with regard to the law school, glad to have a Supreme Court, anything you want.
Thanks so much, Erwin, and good afternoon, everyone. My name is Whitney Mello. I'm Erwin's assistant, and I'll be helping field the questions for him today. And we've got a lot, so I think
okay, go for it. I'll do as many as I can.
Perfect.
And we'll do this. If I don't get to them all, you can always write me, but we'll do more of these, and I'll get to as many as I can.
Excellent. Okay, so first up, how is the law school budget for next fiscal year? Due to high California tax revenues, the governor restored prior cuts to UC and added some 3% enhancements. How much of that filters through to the law school for the next fiscal year?
At this stage, none of it. Now, what I've got to be clear about is what Governor Newsom has done is restore the prior budget cuts and maybe a bit more, but it's not much of additional revenue. The funding of the UC has been dramatically cut over the last decade, and this is just restoring some cuts. It's not additional revenue. But at this point, in terms of campus, the campus is going to cut us from, compared to 2 years ago, by about $2 million. So we're not getting any more money from campus. We're going to be cut by about $2 million. That said, assuming that our enrollment is as it appears to be, most of all, assuming our LLM enrollment holds up, we should be fine financially next year. I don't think we'll have a deficit again. On the other hand, our ability to recruit and keep great faculty, our ability to recruit great students depends on scholarship. And these things so also turn on you, our alumni, and your support. But I'm very confident that though we're not going to get the benefits of that additional state money, the campus will get it. That will help us. But if we can keep our enrollment where we think it will be, we should be fine financially.
Thank you. What can you tell us about the ethnic ratios and percentages for the incoming class?
Sure. I can tell you some of that I don't have the calculations for yet. I know, for example, that as of Monday, we have 42 Black students who are coming in the entering class. And let me put this in some context. My first year here, which was 2017, when I arrived, there were 12 Black students in the entering class, and I was enormously worried about what it would mean for recruitment. And we looked at what was the cause of the problem, and we saw that we were receiving applications and admitting students, but they weren't coming. So we developed a system of aggressively reaching out. We relied enormously on our alumni. And the next year, we increased to 28 Black students, the next year to 33, this year to 43, and we're almost exactly that same number for next year. We have a significant increase in Latinx students over the last few years. We've continued to increase Asian students, and we've had a record number of Native American students coming. So I expect that next year, more than half of our class will be self-identified students of color. As of right now, about 2/3 of the entering class for next year are women students. Of the top 20 law schools, we have the largest percentage of women students. And certainly, once students enroll on August 16th, and we can see who's here, I'll then give you a full breakdown in terms of ethnicity, race, sex, and the like.
Thank you, Erwin. A question we received from an alum by email before the event. Could you comment on concerns raised about, first, the DOJ taking the defamation defense for Donald Trump, and second, the DOJ defending private schools against actions brought by LGBTQ individuals?
As to the former, I am very concerned about why the Justice Department chose to do this. The Federal Tort Claims Act has a provision that says that if sued against a government official in the scope of his or her duty, the only possible remedy is under the Federal Tort Claims Act. So if you sue a federal official for an intentional, other than constitutional violations, any remedy against a federal official in the scope of his or her duties has to be under the Federal Tort Claims Act. Well, you can't bring a defamation claim against under the Federal Tort Claims Act. So what President Trump said is, what I said with regard to defamation was in the scope of my duties. The FTCA is the only remedy against me, and there is no FTCA remedy, so it would have to be dismissed. This was a defamation suit by Jean Carroll. In the fall, the Federal Court of Appeals agreed with the district court and said, this has nothing to do with the scope of official duties. Therefore, this provision of the Federal Tort Claims Act doesn't apply, and Trump has to defend the lawsuit on his own, and the lawsuit gets to go forward. The Biden Justice Department is appealing that ruling. I think that the lower courts were right. I think the Biden Justice Department is wrong in doing this. I just don't think the defamatory statements by Donald Trump with regard to whether he had an affair with Jean Carroll has anything to do with his official duties. Therefore, the suit should be able to go against him individually. I think that here, the Justice Department is just trying to reflexively protect federal officers from being sued, and therefore trying to take a very broad view with regard to this. Hopefully that made sense. As to the second, I'm not sure what it's referring to. Do you have a sense, Whitney, what the second part of this refers to? I should say that the Department of Education today issued a guidance that says that discrimination on the basis of sexual orientation or gender identity violates Title IX of the Civil Rights Act, and I'm sure the Justice Department under Biden will enforce that.
Thank you, Erwin. Now, that was the full extent of the question, and I'm also not familiar with the cases, so I think we'll go from there. But please do email Erwin if you want to follow up further on that question. All right. What is your opinion on the calls for Justice Breyer to step down to preserve the Democrats in the Senate ability to confirm another justice?
I've been outspoken about this. I have an op-ed that came out in the Washington Post about a month ago, urging Justice Breyer to step down at the end of this term. In March 2014, I wrote an op-ed in the LA Times encouraging Justice Ginsburg to retire at the end of that term. I said it looked like the Republicans were going to take the Senate in November 2014. They did. I said there's no way to know what's going to happen in 2016. And that sure was an understatement. And I said if Justice Ginsburg wanted someone with her values and views to take her place, she should retire in the summer of 2014, where there's a Democratic president and a Democratic majority in the Senate. Well, my op-ed with regard to Justice Breyer said the same thing. The Senate is 50-50 between Republicans and Democrats. If one Democratic senator leaves in the next 2 years and is replaced by a state with a Republican governor, the Democrats will lose their majority. There is no doubt, if you just look at what Mitch McConnell said this week, that if there's a Republican majority, they're not going to confirm anyone who Biden picks for the Supreme Court. So Breyer's had a long and distinguished career on the court. He's been there since 1994. He's an excellent justice. He's thankfully, by all accounts, in wonderful health. But if he wants someone with his values and views to take his place, I think he should step down this summer.
Thank you. Do you think the upcoming voting rights cases will present a moral/legal dilemma for Justice Roberts, given his opinion in Shelby and the resulting tidal wave of state voter suppression laws?
I've seen no indication that Chief Justice Roberts has second thoughts about his opinion in Shelby County versus Holder that effectively nullified Section 5 of the Voting Rights Act, the preclearance requirement. I would hope that as the justices decide this case, they'll look at the restrictive voting laws in places like Georgia, Florida, Arkansas, what Texas Republicans were trying to do. But I also think that this is a very conservative court. And keep in mind, there are 5 justices more conservative than Roberts. I guess I have to say, I'm more pessimistic about what the court's likely to do in this case, but I hope to be proven wrong.
Regarding the loss of 2 professors to UVA, I recall your stating at a recent reunion that UVA has edged out Berkeley in the US News rankings, chiefly because, although it too is a public school, it has at least twice the rate of alumni contributions as Berkeley does. Does this also factor into its ability to purloin Berkeley faculty?
In the most recent US News, Virginia is 8 and we're 9. Though interesting, when I went through the categories for you earlier of where we are in IP, environment, criminal law, and the like, we're ahead of Virginia in 6 of 7 of those and tied in 1, which I think shows you something about the relative faculties. I think there's a couple of things to keep in mind about Virginia being ahead of us. One is a key part of what separates the top schools is per student expenditure. We're at a disadvantage because we have lower tuition than Virginia. And we're also a bit larger school, so we do less well on per pupil expenditure. And even worse, US News discounts our per student expenditure by about 20% and adds a bonus to Virginia about 5% based on cost of living. That has nothing to do with anything about the quality of schools. Virginia gets about 56% annual giving from its alumni. We get about 19% annual giving. And I certainly would love to see us be half of what Virginia is, let alone where Virginia is in terms of annual giving. In terms of Bertrand and Joy's making the move to Virginia, I don't think it relates to those things. As Bertrand and Joy have told me, there's a real appeal to them to go to a smaller college town where life would be easier for they and their children over the next few years. Now, as I'm going to express it at a going away dinner for Bertrand and Joy, I really regard us as loaning the University of Virginia, Bertrand and Joy, but I'm hopeful that in not too many years, they'll decide to come back to Berkeley.
Great. And this will be our last question for the day. What are your thoughts about the effect on the Supreme Court's legitimacy of the highly partisan process involving Supreme Court appointments over the past 5 years, culminating in a court stacked with young, extremely conservative judges?
Supreme Court nominations and the confirmation process have always been contentious. They tend to be more contentious the more ideologically defined the president is, the more polarized our society is. During George Washington's presidency, the Senate rejected the nomination of John Rutledge because they didn't like his views on the United States being neutral in the war between England and France. In the 19th century, 20% of presidential picks for the Supreme Court were rejected. In the 20th century, we had the highly partisan fights and the defeat of John Parker in 1931, Clement Haynesworth and Harold Carswell in 1969, Robert Bork in 1987, and the most recent fights that are alluded to in the question. I'm always skeptical about talking about the Supreme Court's legitimacy because I'm never quite sure what it means. Is it the level of esteem of the Supreme Court among the public? Well, conservatives might hold the court more in esteem now, liberals less. Or is there some other measure of legitimacy we should be talking about? But there's no doubt that we've been through particularly bruising fights. Clarence Thomas in 1991 had 48 votes against him, which was the most ever of a justice confirmed. But now we've seen that happen just recently with regard to the confirmations of Amy Coney Barrett and Brett Kavanaugh. There was a filibuster against Neil Gorsuch. So I just think Our society is so divided right now. It's not surprising. It's also divided with regard to Supreme Court nominations. But it's going to be a very conservative court for years to come. I thank you again so much for coming this afternoon. I know I didn't get to very many of the questions. You can always email me about anything, but I look forward to the next town hall, and I'll try to leave even more time for questions then. Thank you, everybody.